Hello everyone and welcome back to Inain's Forensic Classroom. In the last video, we learned what evidence really is and how it plays a key role in every investigation. But today we are talking about a major change in India's legal system. So something that affects every criminal case. India has officially replaced Indian Evidence Act 1872, which was a 150-year-old Indian Evidence Act, with a more modern, more technology-driven law called as Bharatiya Sakshya Adhiniyam 2023. Now, why this change is important is because the old act, which is Indian Evidence Act, was made in 1872, long before the internet, mobile phones, CC cameras, or even the digital documents exist. Now, today evidence is not just about bloodstain or a handwritten letter. It could be a WhatsApp message, it could be a call recording or a server log, or even a CC clip which is stored on a cloud. Now, the legal system had to evolve, and that's exactly what BSA has done. So, the core principles that are under BSA 2023 is Section 56. Section 56 of the BSA clearly states that there are only two legal ways to prove the contents of the document. So Section 56 tells us the evidence can be divided into two main types, which is a primary evidence and a secondary evidence. So everything presented in court must fall under one of these two categories. Now, when we talk about the primary evidence, it is described in this section 57 of BSA. Primary evidence means the original document or the original source itself, which is presented directly before the court. Now, here's what makes the new law modern is the electronic and digital records are also treated as primary evidence. So when we talk about the Indian Evidence Act 1872, document means only the physical copies, physical documents. But now when we talk about the BSA, these documents can also be electronic or digital records. I hope you are understanding what I'm trying to say. For example, now if you record a video on your phone or it's saved on your cloud server, both are considered original because they were created at the same time from the same source. Now I'll give you an example. You record a crime on your phone, okay? That video that you recorded, which is present in your phone, is your primary evidence. Even if it is automatically backed up in your Google Drive or your iCloud, that copy is also treated as the primary evidence because it is the original document. Now, when we talk about the key points of the primary evidence, the key points is it must be the original source. There must be an original source. If the document is created in parts, for example, you have recorded a video which is in parts, each part of that video is your primary evidence. Okay. Now, the digital files that are stored at the same time in multiple locations, for example, you have stored it in multiple devices, your computer, mobile phone, or different server, all of them are the primary evidences. For example, I'll give you an illustration. If you print 10 posters from the same printer, all the 10 posters are the primary evidences of what is printed on them. But to prove what was in the original computer file, you must show the digital file itself. Now, the second evidence which is important in BSA is the secondary evidence, and it is described in the section 58 of BSA. Now, what is secondary evidence? Primary evidence was the original. Secondary evidence is the substitute. Uh, when do you use the substitute in the court of law? When primary evidence is not available, or the primary evidence is lost, it is destroyed, or it cannot be produced in the court for valid reasons. This secondary evidence can include the certified copies, or it can be the photocopies or scanned copies. It can also be the oral or written documents. It can also be the testimony from someone who has examined the original, or your digital or mechanical copies, which are produced through the reliable processes. Now let me give you an example. Suppose you have an original file, okay, but this original file was destroyed in the fire. Now you have lost your original file. What will you show to the court of law? Say that you have a certified photocopy which is issued by the government office. Now that copy can be used as the secondary evidence. That photocopy that is issued by the government can be used as the secondary evidence. But in the court of law, you must prove that the original existed and why you cannot present it in the court. Now the key points of the secondary evidence is it must be properly authenticated, and it is only admissible when the original is not available. Now, the court requires a valid reason for accepting secondary evidence. Now, why this distinction matters between the primary and secondary evidence is court actually relies on primary evidences more because it is the most reliable form of the truth, and secondary evidence is only accepted when primary evidence cannot be produced and there is legally a valid reason for that. Now, in the serious crimes, evidence decides who is guilty and who is innocent, and that is why this new law, BSA, gives digital evidence a strong legal status. This modern law ensures that digital evidence is not just valid, but it is a powerful tool in establishing the truth. Now, when we conclude our today's topic, under the Bharatiya Sakshya Adhiniyam 2023, evidence is not just the paper anymore. It is more of a digital or electronic record. It is dynamic and it is the backbone of the justice. Primary evidence does bring the truth directly to the courtroom, and secondary evidence also steps in when the original is unavailable, but only with some strict checks to ensure the fairness. In the next video, we will discuss other types of evidences that a forensic professional should know. Till then, take care and make sure you like, share, and subscribe to Inain's Forensic Classroom. If you have any questions, please drop them in the comment box. Thank you. Bye.